Mr. Kobolinsky. This is 25P 177945.
Yep.
And this is a ticket for overtime parking in a lot, 23 minutes without paying. You sent a letter that basically defines parking in a way very different from the state of Michigan's definition. Basically indicating that you never parked your car, you were standing. Let's look at the definition of a standing vehicle. Well, let's look at the definition of parking a vehicle that is found at Michigan Compile Law 251.38. And parking is defined as parking means standing a vehicle, whether occupied or unoccupied, upon a highway when not either loading or unloading, except when making necessary repairs. So as to your letter, your car was parked pursuant to the Michigan definition that has been in effect since September 23 of 1949. Whether you're in the car, the engine's on, doesn't matter. It's parked. You indicated that you weren't in the lot over 15 minutes, and yet the photographs show that you were in the lot 23. Mr. Kobolinsky, how do you get to the fact that you weren't there for 23 minutes?
Okay. I went there to pick up a friend. And can you hear me?
Yeah.
Okay. I went there to pick up a friend. And I've never been to that place before. So I researched it on the internet where it's located. And I get there and I pulled into the lot. And the train was not there. My friend was not there. So I drove through the lot and I exited the lot. Then I drove around a little bit in Royal Oak and I came back. But while I was coming back, my friend called me and told me that the train was late. So he'll be arriving late. So I drove through the lot a second time and the train wasn't there. So I drove back out. And then I came back a third time. I drove through the lot. Again, the train wasn't there. And I drove back out. And I drove around a little bit and I came back. The fourth time I came back, the train was there. And when I pulled into the lot, I saw him getting off the train and walking down the walkway towards the parking lot. So I was driving through, I stopped. I did not turn off my car. I did not get out. He came to the back door, he put in his luggage. He came to the front door and jumped in, and then I left. So there's 4 times I was in the lot, but I only see 2 pictures there. So if you really want to see the whole picture, everything that was going on, you'd have to get the rest of the pictures and look at the process, because I don't know what pictures they have. Did they get the first picture, second picture, third person picture? If they took pictures at the beginning of my journey going through the lot, and then they took the last picture of the last time I left the lot, yeah, that would be a lot longer. Or if they took a first picture and the third time I left the lot. So really, to get a
Responsible next.
good understanding of what's happening here is to look at all the pictures. But I never parked the car in there. I drove.
Yes, you did park the car.
No.
Parking is defined by the state of Michigan. Your car was parked. Your car was stationary in a lot.
Okay, I did some research too, and I looked at those ordinances, okay? And
I don't know whose ordinances you looked at, but the Royal Oak ordinances are consistent with the state law that defines parking.
Well, I'll just read the summary.
This guy might actually be a yoga enthusiast. It's possible he has done yoga. It's also possible that he's attended a WNBA game. I'm not sure. I'm not making allegations. I'm just saying these things are possible.
unless you want me to read through all my pages of research. But here's
I don't need to read the summary, sir. The state law is very clear. I read it to you.
well, I'm looking at it too. So it's a matter of
No,
interpretation.
you were quoting, in your letter, you quoted something else. It had nothing to do with, your source was Google. It wasn't the state of Michigan.
No, well, that's the first time. But then afterwards, I started going at researching it through AI, and I'm referencing here Michigan Vehicle Code Act 300 of 1949. I'm referencing MCL 257.6, MCL 257.674, and MCL 257.675.
Try
I've done some research.
257.38.
Well, they didn't reference the area I researched.
I don't know who the they is.
I don't want to go ahead. I'm just telling you, I did not park.
You did not cite 1949 law to the Chisnator. You did not do it. We're going to get in the Wayback Machine and we're going to start over because that didn't happen.
You did.
And I was standing. But your complaint, your issue really is it's a time issue. So I was not parked. Even though I may have stopped, I was not in the lot for 23 minutes because I was driving through. That's what the citation says. It says overtime in lot. I was not in the lot that long. I was driving through.
Each time you entered the lot, they took the picture of the plate. Each time you left the lot, they took the picture of the plate.
Yes.
The trips that were less than 15 minutes would not have resulted in a ticket. One of the 4 trips that you mentioned did amount to 23 minutes and 3 seconds, and that resulted in the citation.
Okay. Well, can I get all the other pictures, the evidence that's against me? Can I see the whole picture, the full evidence? Can you email that to me?
No,
I'll look at it right now.
I'm looking at the 3 that resulted in this ticket. The other ones are not relevant.
Well, I don't know if these are applied. I mean, fully applied, because there's other times I've been through the lot. I don't know if this
Mr. Fraser, is there any way that a driver can get out of the lot without the picture being taken?
Unless they go through the wrong way, which this one is an entrance and exit. No, like if you were coming out of P7,
It's just a grinder mishap, Judge. Chisnator wouldn't even know what that is.
and like exiting through an entrance, yes, but this one you can go in and out both entrances and exits. So this particular lot, no.
There is a lot, or there was a lot, Mr. Koblinski, that this problem could have happened in, when you could get in and out without the camera. But this lot, you can't do it. You can't get out without the picture being taken, and the computer doesn't generate. Mr. Fraser, is there a way that you can see the ins and outs to that particular date and time?
I have one other one that I'm looking at right now. They entered the lot at 3:09 and then left at 3:12. That is the only other one I could find at the moment. But that's the only other one I got.
I'm telling you, it didn't take me 23 minutes for me to see my friend, have him walk to my car, throw in his luggage, and then for me to leave.
You spoke to at least 3 trips.
Well,
this wasn't necessarily the last trip. What time did the train get in?
I don't know.
So we don't know if this is the second or the third.
I went to the lot like 4 times and I came out like 4 times.
Right.
And my concern is maybe you're not looking at the right pictures. And
each of the exit pictures is paired with an entrance picture.
Is that how they do it? It's a pairing?
Yeah. So somebody could come into the lot, stay 20 minutes, leave, come back, stay another 20 minutes, and end up with 2 tickets. Or somebody could go into the lot, stay 14 minutes, leaves, come back, stay 14 minutes and leave, and get no tickets because there is a 15-minute grace period. I say grace, what they mean is the first 15 minutes is free. And so this, and it's your testimony that none, as I understand it, what you're saying is none of your time periods in the lot exceeded 15 minutes.
Well, I know you don't want, can I read this to you? It's short.
No, just address the question that I posed, please. Are you saying that on none of your trips did you stay more than 15 minutes?
I don't know the exact time, but I know I wasn't in there very long. My buddy came down the rampway. He threw his stuff in the
Which
car.
was trip number 4.
Pardon?
That was
It would be
trip
the
number
last-
4.
It would be the last one, of course. Then I left to go home. And
So my question to you said you made 4 trips into the lot and left the lot 4 times. I'm asking you if it's, am I understanding you correctly, or are you not saying it? That none of those trips exceeded 15 minutes.
I wasn't clocking myself. It might be possible, but I really wasn't in there that long. I don't want to lie to you, okay? I wasn't watching my watch. I pulled in, the train was there. He got out of the train, he walked down the ramp, and he went into my car, and we left. I did not hang out there, or, it might have been 15, maybe 16, maybe 14. I don't know. I really don't know.
Okay.
But
Well, that's why I asked you what time the train came in, so we'd know if we're looking at
I don't recall.
trip number 1, 2, 3, or 4.
I don't recall the time. But I don't understand it, because if you have that, if that's a train station, okay, people are always coming and going, People are driving in, picking up their mother, father, brother, whatever. You should allow time for them just to come in, have them get on in their car, and then drive off, right? I mean,
No.
No?
No, it's a lot that people pay to be in.
But isn't it also a pickup place?
It's a pickup, it's a drop off, but it's a lot that is owned by the city, and they're charging people to park on their lot.
It's a pickup place for you, wasn't it?
I wasn't parking.
Yeah, you were.
And I know. Okay, can I say one more thing? There
Go ahead.
is
could.
a sign right between the bus station and the Amtrak lot. Okay, there's a sign there, and I took a picture of it. Let's see. Can you read that?
Yep.
So if parking is the same thing as standing, why state standing on this sign? Why not just say no parking, no stopping, and no parking?
Oh yeah, clearly this sign implies that you can park there. That's the argument you're cobbling together here. You're showing that sign. You're showing that effing sign to the Chisholmator for the proposition that you can park in that location. You've got to be kidding me.
Why state standing? Standing has a special function. It has a special understanding to standing. It's different than parking. That's what I've read it on the internet. That's what this sign is indicating. Your Royal Oak laws recognize standing as something separate from parking.
No, it doesn't.
Okay. I'm not a judge. I'm not a lawyer.
The word standing is used in the definition of parking.
But it has,
Parking.
it has its own identity.
Parking means standing a vehicle. That's the state law.
And my researcher says, in a parking lot, a standing vehicle is generally understood to be one that is temporarily stopped, often with the driver present, for the purpose of actively loading and unloading passengers or materials or waiting briefly as opposed to being left stationary for an extended period, which would be considered parking. That
Okay. The Michigan statute does carve out loading or unloading. So if a vehicle, parking means standing a vehicle, whether occupied or unoccupied upon a highway, whether loading, when not loading or unloading. So if you're loading or unloading, you're not parked.
I was loading passengers, my friend. I'm not parked. I'm standing.
He didn't unload till later that night.
If he was there getting into the car, but waiting for him 22 minutes is parking.
I wasn't.
Now, I'm going to waive the fine and cost because I know you put a lot of effort into this. But the bottom line is that the vehicle was there at some point, 23 minutes.
Yeah, I agree. I was there. I totally agree. And I don't know the exact time because I didn't time myself. I didn't know I had to time myself.
Back in the old days, when the parking meters had the red flag that went up, if the flag is up, it's up.
Yep.
You didn't need to clock it unless you wanted to avoid the ticket. But I am going to find you responsible and waive the fine and cost.
Thank you.
And I too am looking forward to the new system that'll be in place hopefully by the first week of January, where human beings will be writing.
Wait, he found him responsible and waived the fine and cost? My God, look at that. Look at that. The Chisholm's heart grew 3 times today.
The tickets instead of machines.
I don't follow. You mean
Royal is doing away with the current parking system.
Okay, where you have to pay to park, you mean?
No, there'll still
cameras.
be the obligation to pay, but it won't be done. The enforcement will not be done by computers and cameras.
Huh, okay.
It'll be more along the lines of what they're using in Ferndale and the city of Detroit. I'm not saying it's the same system, but it'll be more on those lines.
This is going
And
back.
both of those systems work pretty well.
It's going back to the old way of doing it, or
Not completely. The old way of just putting coins in a meter apparently doesn't work because not enough of us carry coins.
yeah.
But the computer doing it, this system, in many, many ways, is probably ahead of its time. But the ambiguity that can come by the fact that you can come and go, and then you get a ticket at the end and you're wondering which one of those trips was the one that triggered it, or did they combine 2 where they got me coming in, missed me leaving, then missed me coming back, but got me leaving? And so could the computer have put 2 trips together in one parking time to exceed it? It's really a very sophisticated system that works a lot of the time. And I'm very encouraged to see human beings getting back into the system. So I've waived the fine and cost. You are good to go, sir. Have a good day.
Hey, you too. Thank you very much. What's your name, sir?
Chisholm.
Chisholm?
Yep.
Okay, thank you.
Thank you.
Can I leave now or what? Or
You are good to go, and I can help you.
Entirely inappropriate for a venue change.
Did he say you're good to go and I condone it? I love it.
Because someone's father is running for city council. It just doesn't make any sense to me. And I understand he's asked you to make that argument. But if you're going to make an argument of that nature, you're going to have to do so in writing with facts that support it or allegations that would make something like that even within the realm of possibilities. because I know of no law that would make that appropriate.
Fair enough, Your Honor. I will look into briefing.
Yeah, I mean, if it's briefed, but and funny enough, I'll just point out that I referred Mr. Drouillard to another jurisdiction for mental health court, and he decided he didn't want to do it. So it's not like there's any allegations that I'm somehow holding on to this case because his father is running for city council. A matter of fact, I referred him to Wyandotte, and he refused to participate in the program, which is why he's with me. So I'm not holding on to this case for any sort of
Yeah, he didn't want to do that in front of his swinger club friends.
proper purpose. I have jurisdiction. It's a 23rd district court case. I don't know his father. I don't know him. And I look forward to reading your brief with some sort of legal basis that would justify a venue change. Now, Mr. Drouillard isn't here today. He alleges he's in the hospital. He knew he had to be here today. I don't have any documentation showing that, so he has an immediate warrant. He has multiple violations pending. He has allegations. One of his conditions was drug screening. He's had multiple dilute tests. We have tests pending right now for cocaine use. And I'm not inclined to just continue to push this out because Mr. Drouillard doesn't want to face consequences of his actions. So we'll have an immediate bench warrant for his arrest. And counsel, I'm not giving you a hard time. I know you have a client. You're just trying to do your job. I think that's a frivolous request. And I'm sure that the case law will bear that out. So.
Thank you very much, Your Honor.
All right, we're all set.
Thank you.
Are we ready on arraignments or
I
not?
think he's Dawn's just getting some papers. He'll be back in here.
Okay,
I know he's talked to him.
all right. All right, so sir, on both of these, I'm giving you a personal bond. On the OWY, you've got a $2,500 personal bond. You don't have to post any money. On the allowing an unlicensed driver to drive, you have a $1,000 personal bond. Again, you don't have to post any money. Sir, these are your bond conditions. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot consume alcohol or illegal drugs. You may be subject to testing on demand. And obviously you cannot operate a motor vehicle without a valid license. And Mr. Payne will send you notice of your court date in the mail.
Okay, thank you.
All right, you're all set.
Thank you.
Next to Mr. Jones, Your Honor.
All right, this is 252-308 and 252-309. The People versus Akeem Jones.
Good afternoon, Your Honor. Jeffrey Phoenix on behalf of Mr. Jones. Wait for more reading, stand mute.
All right, Mr. Jones, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes.
Did you understand your rights?
Yes.
Did you give your attorney permission to sign your name on that form?
Yes.
All right, I've entered a not guilty plea for purposes of arraignment. I've also signed the ex parte order preserving evidence and the appointment of an attorney.
Detroit traffic, Hazel Park. Hazel Park's a strange number, so it looks like that would be a money only situation. And last contact, last condition 19 would ask for personal bondage. Good boy, and he's recently moved into the city of Taylor.
All right, I've entered a not guilty plea on his behalf, sir.
All right, I need to thank Deluxe Crusader, Brecken, and Law Nerds Unite for this mess.
see limited contact. I'm going to give you bond conditions. On each of these cases, you have a $2,500 PR bond. So you don't have to post any money. These are your bond conditions. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot have any contact with Akila Vincent. Do you understand me?
Yes.
You can't go to where she lives, works, or goes to school. You can't have anyone contact her on your behalf. No third-party contact, with the exception for your attorney if he believes it's necessary. You cannot possess or have access to firearms or dangerous weapons. You cannot consume alcohol or illegal drugs. You may be subject to testing on demand. And you also cannot return, obviously, to Akila Vincent's home address. You understand?
Yes.
Anything further?
Mr. Jones,
I ask, like all of my stuff there, can I get a police escort to get over there?
Yes. Yes, I'll allow you a one-time visit to obtain your personal belongings accompanied by a police officer. And you must provide us with your new address within 24 hours of release, okay?
Yes.
So when you get out, ask the police for a standby and they'll provide you when they are able to do that. And then also make sure you call the court within 24 hours and let us know where you're staying, so we know where to send your court notices. Understood?
Yes.
All right. And is her address? Yep, don't go back there without the police to get your belongings. And you're all set.
thank you.
Next will be Mr. Jones, Your Honor.
So yesterday, did I give him bond conditions?
I assume you did, Your Honor.
All right, this is, let's see, 252310, 252309 and 252308, the People versus Akeem Jones.
Your Honor, two of those files you was waiting on yesterday. The 252310 OT is the new file from today. As
All the
today,
time.
Your Honor, waive reading of the complaint, stand view. And
Mr. Jones, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes.
Did you understand your rights?
Yeah,
And did you give your attorney permission to sign your name on that form?
Yes.
All right, I'm entering a not guilty plea on your behalf. I need a second with this. So I saw him yesterday
Yeah.
and told him he couldn't have any contact with Akila Vincent and he couldn't return to her home, right? Does this all sound right so far?
Yes, ma'am. I'm sorry. I was.
okay, Mr. Jones, hold it.
Wait, Mr. Jones. All right, so then I let him out yesterday. I gave him bonds, right? He got a personal bond on these two cases and he wasn't allowed to go back to the house. So he gets out and then the next day there is an allegation that he's returned to the property. And so he went back there literally the day after I said no.
Same day, Your Honor.
Same day, okay. All right, so I take it that he does not like personal bonds.
Yes, I do, ma'am.
No, you hate them. You hate them.
I'm sorry. I do. I just.
No, you hate personal bonds, sir, because when I give you a personal bond and you like a personal bond, you do what I say. You don't go back. It was a court order. You weren't to return to her residence. You weren't to have any contact with her, and you did on the exact same day the thing I had just told you hours before not to do. So you can't have a personal bond. Because you don't do it, you have a $25,000 10% bond with the GPS tether. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change with the complaining witness. And I'll say this again, Akila Vincent. You can't go to where she lives, works, or goes to school. You cannot go there for any reasons. You cannot possess or have access to firearms or dangerous weapons. You cannot consume alcohol or illegal drugs. You'll be subject to testing on demand. And again, that's with the GPS tether. Okay, anything else? All right, thank you.
Next will be Mr. Connor, Your Honor. Leave that there. Don't touch it.
Don't touch it. Hello, Your Honor. Is there a reason I can't hear, officer?
Yeah, because they're not talking to you.
Yes, sir.
So, I'm sorry. Hi, sir.
Yes.
This is 231105, 220875, and 251539, the People versus Justice Connor. Mr. I had it muted, so he hasn't heard anything.
Okay. Good afternoon, Your Honor. James Gazicki on behalf of Mr. Connor. Waive reading of the complaint, stand mute, request a personal bond, Your Honor.
All right, sir, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, ma'am.
Did you understand those rights?
Yes, ma'am, I did.
And did you give your attorney permission to sign your name on that form?
Yes, Your Honor, I did.
All right, I've entered a not guilty plea on his behalf. Counsel, he has, so we have cases from 23, 22, and then he picked up this new one in 25. So this is his new case. He's got these old cases. He had one he never came to court on. He had another one back in May of 22. He was given a personal bond. He never came back to court on that either. So he also has warrants out of Romulus, MSP South, Lincoln Park, and Allen Park. Are these all traffic?
Yes.
Looks like that.
Yes,
Well,
Your
what
Honor.
am I gonna do to get him to come to court if I don't give him a cash bond?
I'm working on it, Your Honor. I've been going through a hard time with losing the mother of my children. I've been a single dad for the last 3 years. I am working on getting those warrants and everything paid off and getting my court dates arranged. I just really need a break on this one. A personal bond would really help me out on getting out.
The world frightens and confuses me. My primitive mind can't grasp these concepts.
And getting back to my 3 children. And like I said, I do everything as a single father, so I'm just trying to play catch up and just do the right thing.
So he has a theft case, looks like that's 24th district for fraudulent activities. He has a bench warrant on that. He also has this Oakland County case, a district court case, and I'm surprised they don't want him because it looks like he quit showing up there too.
I spoke to my attorney for the Oakland County case, and they said that the case that was dropped due to whatever, the person got their money back. I don't understand what was happening with that. But as far as when I did call, there was no set court date to show up to, ma'am. Like I said though, yeah, you have my word that if I am able to, if you are able to give me a personal bond, I will show up to that court date. I'm working on getting the rest of this taken care of. I'm just trying to take care of my children as a single father and work and be a normal person in society.
Wyandotte wants him though. They'll pick up statewide, they said. Allen Park said they'll pick up within 25 miles. Romulus said they'll pick up.
I was advised and released the last time that I had a traffic issue. Not sure. I really just need a break, Your Honor. Like I really do. I need to get back to my children before they end up in the system, and I need to finish this job so I'm not in that and lose my children.
I mean, on the 25-15-39 case, on the unlicensed driver case, enter a not guilty plea on his behalf. On this one, he has $1,000 personal bond. On the no license case, again, these are just, I mean, it's silly. You don't come to court on cases like this because half the time these are just resolved with a fine or even dismissed.
Like I said, Your Honor, I've been having a lot of issues. The mother of my children just passed away.
No, listen though, Mr. Connor, everybody in there starts a job tomorrow or has something going on. I mean, I hear it all day long. It's really losing its effect. I mean, the larceny case is the only one I would have given him a bond on, and it's Walmart. Up. They're not showing up to court. You should show up on that. Because guess what? Walmart never comes to court. And all their cases end up getting dismissed. So I'm not going to hold you in jail on a case when I already know that the complaining witness, Walmart, is not coming to court. Since I've been on the bench, I think they've shown up maybe twice. Yes, so you're lucky. You're alleged to have stolen from the right place because they don't show up to court. So you should probably really come and see what happens.
I'm working on getting that
on each of the cases. You have $1,000 personal bond. These are your bond conditions. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit new crimes while released. You're to immediately notify the court of change of address or phone number. You can't go into Walmart.
Yes, ma'am. So
you cannot consume alcohol or illegal drugs. You may be subject to testing on demand. You cannot operate a motor vehicle without a valid license. If you do not show up to court, Mr. Connor, on your next court date, I will not give you a personal bond.
Yes, Your Honor. I just want to thank you so much. I really do. Me and my
show up. Show me how much you appreciate me by showing up to court.
So just for clarification, the personal bond is.
You don't have to post any money. You have personal bonds on all the cases. You're going to get a court date in the mail. If you don't get it in the next week or two, call the court. You have old cases that might disappear if you show up. They might be dismissed. I've told you, I've seen Walmart show up to prosecute a case twice. So if you don't show up, you end up back in warrant status and you'll do some more time in Taylor. But you're all set for today.
But I'll be okay. So personal bonding.
He was seen on the warrants only. He has a new pending charge. You're not seeing him on that today?
I didn't. Is that the Walmart case?
No, it's a domestic violence, Your Honor.
Oh, no, I don't have that.
Okay. All right. Just checking. Thank you. Have a great afternoon.
All right. Thank you. Hi, Officer Ziegler.
Hey, Robert.
Who are we seeing first?
This is Mr. Payne, Your Honor. Stand up.
All right, sir, can you hear me okay?
Ma'am, good afternoon.
All right, good afternoon. This is 252312 and 252313, the People versus James Payne.
Good afternoon, Your Honor. James Gazicki on behalf of Mr. Payne. Waive reading of the complaint, stand mute. Your Honor, this is kind of a bizarre complaint. He's charged with allowing somebody to drive a car and operating while intoxicated all at the same time. And also the vehicle he was driving was parked in a gas station. So I don't know what the facts are that are going to support these charges, but the probability of a conviction I think would be slim. So we're asking for a discovery order and a personal bond.
Okay, sir, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, I did.
And Mr. Payne, did you understand your rights?
Yes, I do.
Okay, and did you give your attorney permission to sign your name on that form?
Yes, I did.
All right, I've entered a not guilty plea on your behalf for purposes of plea on both charges. I'm signing the order for a court-appointed attorney and the ex parte order preserving evidence. And then, see, he's got some traffic holes, but nothing aside from that. So, and some criminal history, but not in recent years.
Case of R&J Group Holdings versus Saffold.
Good morning, Your Honor.
Morning.
Anthony Momina here on behalf of plaintiff R&J Holding Group Holdings LLC.
Azar Saffold.
Oh, yes, it's Boris and Natasha back again. I haven't seen it. Everybody told me about it, but I was busy. I was busy streaming that horrific hearing from earlier, which was interesting but terrible.
On behalf of myself and my family.
Okay, where are we on this?
Your Honor, this is our motion to seek distribution of the funds held in the court's escrow account related to this case. Just to recap, two $5,000 payments total, which was the lease payment amount, incidentally, were placed into the account pursuant to the standard escrow order that was entered during the pendency of the case in chief. And then subsequent to the issuance of a judgment of possession, there was an appeal, and Your Honor entered another order, a bond on appeal, yes, under which two additional $5,000 payments were made into the court's escrow account. I've confirmed with the clerk that $20,000 is currently being held. There was an appeal, obviously, hence the appeal bond. That appeal was dismissed by the Washtenaw County Circuit Court. There was a subsequent appeal to the Court of Appeals that was processed as an appeal of right when in fact it should have been otherwise, and that court dismissed the appeal. So there are no pending appeals on this matter, Your Honor. The matter is final and closed. And as an administrative action, I would ask that the court authorize the distribution of those monies to my client. Thank you.
Response.
Well, according to MCR 3.31, this was an injunctive bond that supposed to protect both of us because we counter complained against.
Why was it it wasn't an injunctive bond.
It should have been because we apply for restraining order against the plaintiff, and it.
I had that question myself. I'm like, yeah, you know, again, I'm just a simple country lawyer over here in the Midwest trying to bang out a living, but I don't know about this injunctive bond concept we're talking about.
Wasn't granted, but this plaintiff case still is in pending status with federal court, and we paid $10,000 security deposit. We want them back, and we also paid for over $44,000 of expenses that we paid the property taxes, we paid the homeowners insurance, we update and upkeep, and they even charge us attorney fees, Your Honor. And I have the sheet to prove it, and therefore we are entitled to this $20,000.
Why don't we get clear, first of all, what
that is a perfect summation, Bob.
The $20,000 is. The $20,000 was escrow pursuant to the basically summary proceedings action that had been filed. That is not under Section 3 of the court rules. That is actually under Section 4 of the court rules regarding the issuance of an escrow order. I issued that order. You complied, as counsel has indicated, with 2 months of that. Albeit late, there were 2 payments put in. Judgment was rendered. You appealed that judgment. Also pursuant to the court rules, in, again, Chapter 4, you will see that the bond on appeal, I could have set it theoretically at whatever, or whatever bond, But where there has been an escrow order, that escrow order then effectively becomes the bond on appeal. And that's what happened. And so then there were 2 additional payments prior to the dismissal of the appeal that then makes the 20,000. So that we're all, well, whether we're not on this.
I mean, this is cute. What Judge Simpson is saying is all correct, but she doesn't understand, she doesn't care, and she doesn't want to understand.
We can all be on the same page or not. That's what happened, and that's why the 20,000 is there. I don't know what you're talking about in terms of injunctive relief. I don't know any of that. That has nothing to do with me in this court. The purpose of that and the 5,000 was the amount of the lease, basically the lease price of the premises.
Exactly.
All right. You were in possession of the premises up until such time as the writ. I don't know if the writ has been executed or not.
And the return has been filed by the sheriff.
Got it. So you would have had to have paid that amount to be in possession of the premises up until whatever point in time and during appeal. So I'll let you make additional argument, but it seems to me that the 20,000 should be paid over to the plaintiff because of your occupancy of the premises.
Permission to speak, Your Honor?
Go ahead.
What about our security deposit, Your Honor? What about the payment of property taxes and homeowners insurance they forced us to pay in anticipation of the sale, which they breached the contract and they never did, Your Honor?
That would have to be taken up someplace else in terms of the property taxes and whatever. In regard to the security deposit, the security deposit is the disbursement of the security deposit is taken care of pursuant to an entirely different statute.
I beg your pardon?
That's.
I want an update on the federal case. How's that going, Natasha? Lay it on us. I want to hear all about it. And you probably have something going in the Hague by now as well.
There's the Security Deposit Act, which governs how that is how that gets returned and or not returned, what it can be applied to. That's not before this court.
Which court is this before, Your Honor?
Pardon?
Which court should I go and ask for return of?
I can't give you legal advice. I'm just saying that issue, I'll put it this way, that issue is not before the court. That has not been raised as the return of the security deposit. Usually is something that takes place after the tenancy. Sometimes it's dealt with during the course of a summary proceedings case, certainly, but that has not been raised here and is not before the court.
I'm raising that today, according to ex parte emergency motion and file, Your Honor.
I don't know that it would be, I don't know that all of the compliance, Gustavo, the act is very specific about certain things that have to happen in order for an issue under the Security Deposit Act to be right to even be heard before the court. I'm not even sure all of that's happened. You can't just say, I need you to deal with this. That's not how it works.
Okay, I petition again, Your Honor.
Well, you can do what you want, Ms. Staffeld. I'm just telling you, I'm not dealing with the security deposit. I'm just not, it's not before me. But the only issue before me is the $20,000 that is an escrow and its disbursement. Is there anything else you want to say?
Thank you for evicting me and my family out of our house, Your Honor. God bless you.
You're welcome, you manipulative bitch.
Well, I guess you're welcome. I didn't evict you. You evicted yourself by not complying with the lease. So
That's-
don't try to put that on the court. Sometimes people, when they have problems in life, have to take the responsibility for their own actions and can't sit there and try to blame the plaintiff or blame the court or blame everybody else in the real problems because they can't take it on themselves to do the right thing. So to the extent I made you realize that, you're welcome. It's the order of the court that $20,000 will be paid to the plaintiff. Counsel for the
Suck
plaintiff prepare that order so that I can then give that to the clerk and we can disperse that.
Thank you so much, Your Honor. Appreciate your time.
We know this is gonna happen, so we are submitting this right now.
Oh, good Lord. That was a lot of fun. That was a lot of fun. Thanks to all who sent me clips there. We had that weird one just before this. That was random, but this was the actual stream I meant to do. And I'm looking at that because everyone was telling me about it. So I know that was today. So Judge Simpson dealt with this crazy and then went into that horrific double murder case of the foster parents. Oh, good Lord. That was a lot of fun. Now I got to come up with the title and thumbnail. I'll figure something out. Yeah, Simpson was on fire at the end of that. Just a little bit. He just gave her a piece of his mind for 30 seconds. I enjoyed it. All right. Thank y'all for coming out. Good night. I'll see y'all soon.